Hold this thing. You need to hold it for that, man. It's not such a good place to shoot. Just give it one quick shot, you know? Oh yeah, they're there, right overhead. Brothers! What are they waiting for? The microphone going? You got the microphone on?
Yeah.
Good. Give a little explanation here. These buzzards, these are...
Yeah. Is there anybody else here? Bob, man. Is there anybody else here? No?
Not that I know of.
God almighty!
Can you believe that?
What?
My assistant runs away. I gotta have a cord out of there immediately. Fuck, I lost it. Where's my microphone? Look at that, I dropped that. It is turning. Shit. Fucking Randy, let's really do it. Dang, I thought Sal was dead.
Is that for real?
Yes.
I can't even get it. Real thing on it.
People that would be interested.
Yeah, he was out of town. He was out of town.
And then there's going to be another man coming in.
Please, do you go downstairs?
Paul, we're going to go.
I see you. Yeah.
I'm sure you'll get the name for it, but certainly have managed to do that up to this point.
Don't know them very similar approach to the actual, although they'll be talking about church, it will be more of a state versus state before the judge. And I'm capable of bringing forth the wisdom I've been shown as a priest in the life of living in Jamaica and 10 years of my own experience in the church. I'm an example of what they said would happen to you if you stop years ago, whatever that's worth. And not Mr. Heath and some of the other members of the state attorney's office have met people who are examples of what to provide some of the answers, but don't seem to know.
Hi, how you doing, Ben?
So we know it's already.
Hi. Hi, Wade. A lot of activity for a motion. Isn't it?
Got a whole bunch of other cases.
How much time do we reserve? Half an hour for a motion to dismiss?
Is that too much?
Yeah. Hello, Jan. How are you? Good. Nice to see you.
What's necessary, I suppose. Probably important.
Let's get one of the Coptic Times here.
You got a topic, Coptic Times? Can I have one of them?
No sound on my thumbs.
I did. Not even well, that, whether or not they can, they haven't went from official facts to come with any sort of exception to that.
Well.
What? I'm right here. No, that you're supposed to put on the people there. You want to get in there? Yeah. Do I want to get in there? You gotta switch it on? Yeah. A lot of activity in there.
Can they be revised? And they can't be small.
Well, yeah, I would say that in the resolution, we should
Just to be a matter of returning
provide them to be dispositive of this case before the Supreme Court hasn't made any substantive rulings on that. So the only reference in the complaint to any sort of religious connection of these marijuana plants to the exercise of religion is to the extent that they are a holy sacrament of the plaintiff church. I would submit that under the controlling case law, that even if that were shown to be true, that would not entitle them to those plants back, nor would it allow them a legal right to smoke it or use it in any other fashion. There have been no cases, to my knowledge, which are controlling in this court, which have held that merely because something is a sacrament to a religion would entitle anyone to use it. Plaintiff cites in their way the various cases in which the Native American Church has been allowed to use peyote. But those same jurisdictions, when faced with arguments as to marijuana, have regularly denied them. The essence being is that the reasoning being is that marijuana, or peyote in the Indian cases, was an object of worship, and for you to not deny the Indians their peyote, you would have effectively annihilated their religion. But that's getting the cart before the horse. We're saying here that even if it is a sacrament as alleged by the plaintiff, that would in no way circumvent the state law on marijuana or be violative of his federal constitutional due process rights or First Amendment rights. And there are a series of decisions, all of which are in the Fifth Circuit, which the court will allow me, I'll recite to the court and into the record. Which cases are United States versus Spears, 443 Fed 2nd 895, Fifth Circuit 1971. United States versus Hudson, 431 Fed 2nd 468, Fifth Circuit 1970. Leary versus United States, 383 Fed 2nd 851, Fifth Circuit 1967. Reversed on other grounds in 395 U.S. 6, 89 Supreme Court 1532 1969, and affirmed following retrial in 544 Fed 2nd 1266, Fifth Circuit 1977. Those cases are all in the Fifth Circuit, as this court is aware, in which circuit the state of Florida is. All of those cases have held that there is no due process or First Amendment right to smoke marijuana. The case in Florida of Orlando Sports Stadium versus Powell, which is a case in nuisance, has a quote in it which might be, I think, interesting for this court's consideration if I can find that case. Well, I have the case here. I'd like to quote the language if I can find the case.
Just keep in mind, you all had 15 minutes set aside for this hearing.
It doesn't come to mind. I can paraphrase the language of the opinion as to this effect, that the First Amendment right, or that the prescription against the use of marijuana is only elevated to a consideration so long as there can exist a First Amendment right for it to be smoked. And as I say, the Fifth Circuit has consistently held in the opinions in which I just recited to the court that there is no due process First Amendment right to use marijuana in conjunction with the services. Certainly not upon the mere allegation that it is a sacrament. Even if that were shown to be true, that would not be controlling. Therefore, sufficient facts have not been alleged upon which this court could grant relief, even if everything that they have alleged is proven.
Let me, if I may, Dick.
Without refiling the same thing.
My statement will be different, Your Honor. Your Honor, Theodore Klein, Special Counsel of the City of Miami Beach, and with me is Beth Spiegel, Assistant City Attorney. Your Honor, my argument will be very simple, very short. We're here on a motion to dismiss for failure to state a cause of action. Aside from the notoriety of some of the issues which I'm sure the court is aware of, and it does not really matter because those are not a part of this particular proceeding, This is a simple motion to dismiss of a replevin suit. And the four corners of the complaint circumscribe whether or not the complaint states a cause of action or not. The memoranda of law filed by the defendants, which go far beyond the scope of the pleadings at this stage, are really totally irrelevant. All of those items, including affidavits and so forth, constitute a speaking motion. They just are not a part of this complaint.
Did you say filed by the defendant?
I mean by the plaintiff, I'm sorry, filed by the plaintiff in response to our motion to dismiss. We have a replevin complaint in which a plaintiff is seeking the return of a contraband item. It has been declared contraband repeatedly by the courts of this state, and as such, and under the statutes, they simply have no right to a possessory interest in such contraband. The bare bones allegation contained in the complaint that this constitutes a sacrament of their church is insufficient at this juncture to allow them to get the sort of relief that they want. And under those circumstances, we feel that the complaint should be dismissed with leave to amend if the court deems it appropriate for them to set forth whatever facts they think will entitle them to go outside the scope of the clear mandate of the statute which prohibits a possessory interest in contraband.
Your Honor, contraband is described as any substance, article, or thing making possession or trafficking of which is unlawful. In the case of State versus Bryant, 250 Southern 2nd, 344, Florida case, after describing the two different categories of contraband, it says in either category of contraband, however, there is no right of property therein as to the one in wrongful possession or control thereof. Those are the key words, wrongful possession or control. Now we have a clear conflict here with the First Amendment. The Constitution of the United States is made applicable by the 14th Amendment to laws passed by states. Now, Judge Barad, in a recent case, held that the Ethiopian Zion Coptic Church represents a religion within the meaning of the First Amendment of the United States Constitution after hearing evidence. He held that cannabis is smoked as the mystical body and blood of Jesus, which is the way they pronounce the word we pronounce otherwise, and serves as a remembrance of God. It's an absolute parallel to the churches that use the bread, wafers, and wine of the mystical body as the mystical body and blood of Christ, who exhorted his disciples to partake in remembrance of me as oft as ye shall do it. Now, the case of People versus Woody is the peyote case involving the Native American church. They use peyote.
Excuse me, Your Honor, I don't mean to interrupt, but I don't know if the court specifically authorized the use of the electronic cameras and other recording devices that it is going on now.
There's no light on. I don't.
It doesn't matter to me, but I just didn't know if the court was aware that this was happening.
I didn't, well, I'm very familiar with cameras. I didn't give any thought to anybody, you know.
All right, I didn't care. I just didn't know.
It's not that significant. All I'm reminding you of, you set aside 15 minutes for the hearing, which I'm not willing to rush anyone. I want everybody to have full say. After 15 minutes here, you get 15 minutes.
Your Honor, I asked for a half an hour. That was my impression. I'm sorry.
Well, when I checked with Barbara, they said 15, so let me just check. Maybe she shorted you all with me. All right. Yes. Oh. Oh, so. But they won't be here at 1:30. Oh. We're in luck to 1:30. So I give you another 15.
Thank you very much.
Work yourself out, all right.
The case of People versus Woody, which is a parallel case involving the use of peyote by the Native American church, which were some Navajo Indians. Peyote is a psychedelic and a controlled substance under California law. And in resolving the question of the conflict of the First Amendment against that regulation, the court applied the following tests. Number one, whether the application of the statute against peyote imposed a burden upon the free exercise of defendant's religion? And if so, whether some compelling state interest justifies the infringement. Now, we're here on a motion to dismiss. It takes evidence presented to the court to determine whether the state has carried its burden of showing a compelling state interest when you get into a clash with the free exercise of religion. In that case, the court concluded that peyote plays a central role in the ceremony and practice of the Native American Church, and that the application of the statutory prohibition against the use of peyote results in a virtual inhibition of the practice of defendant's religion. Judge Barrett found and concluded that the use of cannabis is an essential portion of the religious practice of Ethiopian Zion Coptic Church, and the word essential is a stronger word than central. The Woody case said central to the religion, but Judge Barrett found it was essential to the religion.
Your Honor, I could just interject here.
No, please don't.
Well, I don't see the efficacy of citing whatever Judge Barad's findings
I don't know,
were,
next to this court in
unless you
town.
want to stipulate to what Judge Barad's ruling was, which we'll be very happy to do.
Well, the judge has a copy of the ruling attached to my memo. It's not binding on the court, I know that, but it's persuasive, Your Honor, in showing what questions are involved. Now, in another case, a case of the investigation of Brother Love, a subpoena was issued to Brother Love, and he was questioned at length by numerous assistant state attorneys. We then filed a motion to quash that. Judge Gordon, John I. Gordon, announced that an evidentiary hearing was necessary on the following issues. This is another circuit judge. A, whether the Ethiopian Zion Coptic Church is a religion protected under the First Amendment of the U.S. Constitution, which Judge Barrett found in the previously cited case. 2, whether the use of cannabis by members of Ethiopian Zion Coptic Church is a bona fide sacramental use so as to be protected by the First Amendment. Thirdly, whether there is a compelling state interest in the regulation of cannabis sufficient to outweigh the interest of the individual members of the church to freely exercise their religion. So we got, on a motion to dismiss, we get to the point where is it necessary for the court to take evidence to determine whether there's a cause of action that can result in a ruling in favor of the plaintiff. When we allege it's a sacrament of the church, that is taken as true for the purpose of this particular hearing, which then shifts the burden over to them to show there's a compelling state interest, which takes evidence. It certainly takes an answer. Now, as a result of the judge orally announcing that he was going to have an evidentiary hearing on those questions, the state released Brother Love from his subpoena and mooted that question. Now, the Supreme Court of the United States, which is the ultimate forum for questions involving the First Amendment, has said that the government of activities central to an individual's sincere religious beliefs violates the free exercise of religion clause unless the government officials show a compelling justification for the regulatory effect. Just what I said, and which requires an answer from them and an affirmative allegation to that effect. Now, the government must assume the burden of proof and show that the regulation of religious activity furthers important and legitimate government interests, which requires evidence as to all the circumstances of the possession and use of cannabis by the Ethiopian Zion Coptic Church members. And the government must show that there exists no less restrictive alternatives. There are alternatives to banning the smoking of marijuana by members of the church. Now, this is a case for the possession of marijuana plants, and one cannot use it as a sacrament if one cannot possess it as an object. Now, in there are other things that should be taken into account in connection with this motion. That is the cases which have been surfacing in other courts and also this court. For example, the Sandra Lee case, Judge Durant of this circuit ruled that Section 893.13.1e Florida statutes as applied to marijuana use in the home is unconstitutional. The Honorable Wallace Sample Circuit Judge, upstate, certified a question to the Supreme Court of the United States, Supreme Court of Florida, which is presently pending. Do the findings of the legislature in Chapter 413 of the laws of 1978 create per se an unreasonable classification of the controlled substance cannabis in Schedule 1 of the Florida Comprehensive Drug Abuse Prevention and Control Act? That's Fort Pierce. 11 states have granted the Native American Church a sacramental dispensation as a result of the People v. Woody case. The Roman Catholic and other churches were given privilege to use alcoholic wine for sacramental purposes despite the prohibition laws. The Supreme Court of the state of Alaska has ruled that it's constitutionally protected to use marijuana in one's home. Now, we're asking that it be allowed to be used as a sacrament of the church under such controls as may be necessary and with such guidelines as may be appropriate. That's why we say, regardless of the law stating it's contraband, it is not a wrongful possession. It is protected by the First Amendment.
Your Honor,
Yes, that's
if I may, I'd like to respond.
Make it brief.
Very briefly. Again, Mr. Booth has gone far afield from what we are here for. He's gone into other proceedings before other courts, which have been taken out of context, of course, that irrespective of a single paragraph finding made by Judge Barad, the fact of the matter is that the judge, after taking 3 days of evidence, ruled in favor of the state and the city and found that there was not a sufficient compelling interest on behalf of the state and the city to warrant enforcement of the criminal laws of the state and to provide that possession and keeping and smoking of marijuana at the premises is illegal. But that's neither here nor there. The simple question is, does this complaint state a cause of action? And it is our position that it does not. Now, the second point that I'd like to bring up, and what the court might consider, is abatement of this action pending an appeal of that decision by Judge Barad, which is presently pending by those in connection with that to the Supreme Court of Florida at this time, on the very question of whether or not the First Amendment allows them to possess marijuana in violation of the criminal laws of the state of Florida.
We have that other motion, Your Honor. Brother Love, who sits on my left, who is an elder and a priest in the church, desires, and the plaintiff desires that he be made an additional party plaintiff.
Well, I have to rule first on this motion to dismiss.
Yes, sir.
And in fact, I've been granted. It's, you see, I think the argument here is going much further than what I perceive the issue to be. This is nothing more than a replevant action, get 10 marijuana plants. And using your analogy of the sacrament of the Christian church here, blood or your wine, and wafers, if those sacraments are lost, stolen, something happens to them, actually these sacraments as such get replaced. And so I don't think I get into the whole issue that you've raised in your argument about, the propriety of them using these holy sacraments or not. Religious services, I think it's simply whether these 10 particular marijuana plants, whether you have a possessory right, they should be returned on your private action. And I think state law being what it is, as argued on the state side, that under the laws of Florida, they are contraband, and as such, whether it be in church involved or otherwise, that you do not have a lawful right to have them returned.
Your Honor, I haven't received a copy of the previous order, the agreed order, which continued the injunction in effect. connection with a rehearing, or a motion for rehearing and appeal.
I understand, I don't know what you're going. When was it signed?
I don't know,
Have you all had copies of it?
I sent each copy.
Yeah,
but
I remember receiving it, but I don't remember receiving a signed copy or not. I don't know.
You announced that it should be preserved.
We had no objection to that.
No question about it, you know, you're right.
I think maybe I better resubmit it before I can't find it.
Well, just look through the file, you know. I don't see it.
Those were the papers I filed.
You know, unless it's a loose paper downstairs, I don't see the order here.
Well, that was quite something, I think. As I understand it, we're all in agreement it will be preserved.
You mean your, you mean your
Cause of action just dismissed. I mean, whatever
Well,
happened,
yeah,
of course.
no, but he's talking about his rights under the prior order.
Well,
This case is not over yet.
well, if you're going to take an appeal, we'll
No, I can
preserve
file a motion for rehearing the case is not over.
it. No, well,
Well, no question.
Yeah, well-
2 days from the sign that order. I'm just, let me see if I remember the order being signed. Do you remember the, an order being signed in this case previously, you know, after the last hearing? An order, an agreed order, I think it was, if I recall, an agreed order continuing the injunction. You returned what? Okay. Right, that's fine. All of those orders were returned to Mr. Farrell, because there was something in the order I didn't approve, and I sent them back for them to be retracted.
The same attorney made it.
Never came back.
All right, I'll chase that
That's
down.
all.
Now, may I have 10 days to amend?
Certainly.
I can have it. Huh? Now, how about Brother Love's plaintiff? You want to put that off till the next?
Well, I have to, because since I've granted motion dismissed, there's no action for anybody to be going.
I'll file that amendment complaint. Is it understood?
You have to tell them.
Let's get out there in the hall quick. Let us get out there in the hall. Shut our lights on.
Watch it. Cool, good. Do well. Thank you.
pardon me? Judge's decision. I'm a lawyer doing a job. I'm an advocate.
What's the next step?
Next step, I'll judge feels that worthy of allowed to proceed.
Ken, how do you feel about the judge's ruling?
I think the judge is absolutely correct. To me, it's a very simple case. It does not properly raise the First Amendment questions which the church wants to get into, and the judge just ruled it as such. The present state of the law is that there is no possessory right to contraband. Marijuana is considered contraband. If it gets reclassified by the legislature, then we have a different question. But in these proceedings, it's a very simple one. The First Amendment questions which they are raising have already been raised before Judge Barrage in the injunction suit which I prosecuted, and until that matter is resolved on appeal, I think that they have a proper forum for resolution of all of the controversies which they've raised. I think the judge is absolutely correct. There is no possessory right to possession of marijuana. And it's considered contraband. The First Amendment questions which they raised are not not raise them for any particular proceeding until marijuana is reclassified by the legislature to be non-contraband. I think that that's what the state of the law has got to be. The judge upheld the law and did the correct thing.
What do you think the next step will be?
I think that the church will probably request the judge to rehear the matter and try and persuade him
Key
otherwise.
issues whether or
What do you
not
think will happen out of that?
I never attempt to prognosticate what a judge will do.
Laws against smoking marijuana, possessing marijuana, would apply to allow them to levy or get these items back, which are determined to be contraband under the laws of Florida. Judge Turner held that at least as pled in their complaint, that they did not show any exception or come within any exception to the general rule that marijuana is contraband and cannot be legally possessed by anyone.
Thank you very much.
You're not going to get it.
Oh, well, we have one more business.
And the most important thing is the plants will be preserved.
What was your reaction to the legislature to your request for a special clemency under the law?
I haven't heard from them. When they look upon me and the questions that I'm asking, or the Coptic Church is asking, they're looking upon the questions that millions of people are asking. I sense they would like to be able to take it lightly and push it under the rug. I don't think they'll be able to. I haven't heard from them at all. The initial reaction was one of, who's next?
There have been some suggestions that your asking for the marijuana plants is basically a blatant violation of Florida state law. How would you respond to those charges?
Putting a man in jail for something that God made is a blatant violation of every law that was ever written in the Bible and in the Constitution. It's rape, it's ridiculous. There are mothers in jail right now who should be home with their children, but they're in jail because they had a couple of joints. That's a crime. Growing marijuana is not a crime.
Then it's a crime even above religion, it's a crime also.
It's a crime against humanity. Every man who was ever born found her on the earth already. This United States government in 1936, they changed their laws on prohibition. And in 1937, they made the laws against marijuana. Them thinking it was merely a political issue. It's not a political issue. It's a very human issue when you put humans like me in jail.
What is the status of Star Island worship?
It is now and always has been a Coptic, home of a Coptic member, and God is praised there.
And in other words, you haven't followed the judge's injunction against worship.
The judge's exact words were, of course you can pray in your own house. I pray in my house. God forbid us all from any laws that would prevent a man from praying in his own house. He said that we couldn't have so much traffic.
Has that cut down?
The traffic, we have had a lot of, because of that injunction, not because of our desire, but because of that injunction, a lot of what you call the Miami media people have not been allowed to come in, whereas before they were quite openly, and we would rather have you be free to come in, but if you go back and say something that causes everybody to freak out, so we're just showing our manners.
But you're still worshiping?
Of course.
Are you still smoking marijuana there?
I'm not going to answer that now. I
represent a number of people.
Dick.
I don't smoke pork.
What I read.
I'll wait until everybody gets their license.
The most important thing is the judge ordered the plants to be preserved until our next day. Right?
I won't agree with you that's the most important thing, no. I'll agree that that's what the judge did.
Good. Dick, are you coming over our side or just
Yeah, that's right.
Yeah, just show it in a minute.
I think there's took this kind of stance today that would never bring about any progress. He said that it's against the law, and we all knew that before we started. The most important thing is that he ordered that the plants would not be destroyed until we have a further hearing in the matter. So today was sort of was dull. It didn't end anything at all. It was just dull. That's how I see it. We're gonna start. That's the right way? Am I going the right way? Well, I just want to get a quick comment. Otherwise, you said we're going to come back again for a motion for review. And I didn't fully understand all the legal terms. Basically, it comes like he said that he didn't think we were in the right form. We disagree, and we'll be back. Thank you. That was really terrible.
These judges are afraid to make any sort of decision on their own.
You know how much this is?
WGBS recorder smushed by elevator door. Oops.
On you?
What, this case? All right. Let's just start and warm up.
I see you.
Advance their motion to dismiss.
Huh?
Right?
Yeah, but that came like if you took a shower with and you had a raincoat on.
You want to? Yes, please.
There's going to be a rehearing.
I don't know why he did that. I don't know why he didn't just hear it now. But anyways.
I didn't know it was supposed to be a 15-minute hearing.
Excuse me. Thank you.
We must negotiate in kinds of local media.
This is a shot.
Oh, fuck, man. They're all there.
This is a shot.
Look.
I'll tell you.
Yes. Yeah, they're all. They must know what they did in there just now.
Yeah. That's it.
That's what I was doing. I was when you took the mic from there, when you started trying to move around, and get some shots, you know.
Yeah. Yeah.
You know, I want to get the one that turned into the movie.
Oh, wait a minute.
You don't need that in there. You don't need that in there. On the other side, it's right over.
Yeah.
Get back in the buffalo again. Get a shot. Get everything in there.
Yeah.
One of the security stuff, the mason.
Yeah.
What's going on? tell you this. It's indisputable. Together. Take a smooth shot, man. Hold it steady. Just move it slow, man. Great. Yeah, man.
Yeah.
Do one distant shot from the parking lot.
You can see them all flying. I got those birds in the picture. Those. I got a big 32 with buzzards flying all over it right now. You know what happened?
Huh?
You know what happened, I think? I think they called Elias to come and check it out.
I'm making a documentary, man.
I know it, but they didn't know that until...
If anybody bothers you, just tell them I'm making a documentary. Got a few questions, too. Interview, ICU. You want more shot from the parking lot?
Yeah. Yeah? The only thing I haven't got yet is a buzzard right directly on top of the building. You know?
Move it close up. And then...
Yeah. Want to bet? I can read it right now. I don't know why you couldn't read it on the film.
How did you go from masonry to all this opium?
I sure don't know.
The essentials are pretty good, man.
Two Ross clot. Look at all them vultures.
Zoom in on them?
Yeah.
I need to see this, man. I mean, they really got this thing wired up, and fenced off, and walled off, and then boarded up.
Yeah.
Okay, tell you what, we'll start reading. When I stop reading, then you can stop filming.
All right.
You know, because then you know how long.
Yeah.
Okay. James Dunn, Deputy of the Supreme Council, presented by Tampa Scottish Catholic Bodies, Miami Consultory, Utopia Council of Knights, Kadash, Acacia Chapter Knights, Rose Croix, Minerva Lodge of Perfection, Ancient and Accepted Scottish Rite of Freeman, Masonry, Valley of Miami, Orient of Florida, under the leadership of Will James Dunn, 33rd degree Deputy of the Supreme Council, 33rd degree ANA SR, back of the bill, 10-640. Anybody will be able to read it in that time.
Yeah. Okay. Wickedness.
They got a left west foot when you see the best. After this program.
2 blood clot.
After they see all that shit after they see all that shit in the court, right? Then they get to see the buzzards just flying around and just big too, huh?
Man, they're fucking, look at them all. There's some big ones still, right? Alright, that's good. Yeah. Some boat blew up. 2 bumbleclat. That's a...
Got it on now?
Yeah. All right, well, let's move. Yeah. Yeah.
See what you come back with, man.
Yeah.
Everything from the courtroom battle to the buzzards of Babylon Burner. Hey,
Yeah.
see the column of smoke rising.
Whoa, whoa, whoa to the inhabitants of Babylon.
When those things burn, they just burn, man.
Yeah.
The most get to the fire. You got about a quarter.
man, smell that burnt paint and shit. Fuck. Yeah.
One of them belongs to Joe Basler, and he's Vice Commodore.
Yeah.
Policeman.
Made quite a loud boom.
I don't know.
Wow. What a thing. Okay.
What do you